If you care about whether American institutions can still enforce their own authority, you need to slow down and focus on what unfolded inside a federal courtroom in Manhattan today. This was not a legal dispute. This was a direct collision between individual defiance and institutional control. And the system was forced to answer in real time. For 7 minutes and 23 seconds, a federal courtroom came closer to losing control than it has in decades. At approximately 11:47 in the morning, during an active federal criminal trial connected to Donald Trump, something happened that simply does not occur in functioning courtrooms. 3 defense attorneys stood up at the same time, not after a recess, not after a ruling had concluded. But while the judge was mid-sentence, Robert Sterling, the lead attorney, Jennifer Matthews, co-counsel, and another senior member of the defense team. They gathered their papers, they pushed their chairs back, and they began walking toward the exits. Let me say that again so it lands properly. Licensed officers of the court, attorneys sworn to uphold the Constitution, actively representing a defendant in a live federal trial, attempted to physically leave the courtroom because they did not accept a ruling. This is not normal. Here is where you need to understand the institutional context. Federal courtrooms are not negotiations, they are command structures. The judge controls the room. Counsel argues within that framework or faces sanction. Walking out is not protest, it is defiance. And the system responded immediately. The presiding judge was Patricia Caldwell, a Reagan appointee, 31 years on the federal bench, known among defense attorneys as measured, disciplined, and fair, not theatrical, not reactive. Her response was neither emotional nor loud. She looked at the 3 attorneys and said, "On the record, if you take one more step toward that door, I will hold you in criminal contempt and issue bench warrants for your immediate arrest." Pause there. A federal judge threatening to arrest defense counsel mid-trial is an extraordinary institutional escalation. Judges do not do this unless they believe authority itself is being challenged. What happened next confirms that assessment. Judge Caldwell ordered United States Marshals to block every exit. Within seconds, 6 armed federal marshals positioned themselves at the doors. The exits were sealed. The room was locked down. For 7 minutes and 23 seconds, the attorneys stood frozen in the center of the courtroom. They did not leave. They did not sit. No one spoke. This was not a legal argument anymore. This was a standoff between individuals and the machinery of the federal judiciary. Now, step back, because the trigger did not originate in that moment. 48 hours earlier, a sealed prosecution filing was accidentally uploaded to the federal PACER system. It remained visible for 17 minutes before being removed. In those 17 minutes, legal researchers downloaded and preserved the file. According to multiple sources who reviewed it, the document contained new prosecution evidence, encrypted communications, direct exchanges between Trump and his co-defendants, communications that allegedly occurred during a period the defense had previously described as a total blackout with no contact whatsoever. The filing also referenced wire transfers totaling $4.7 million. One source described it as the most damaging paper trail ever assembled in a white-collar criminal case. This morning, Judge Caldwell ruled all 847 pages admissible. That ruling came immediately before the defense stood up. This is where the narrative shifts from conduct to consequence. Admitting evidence is a routine judicial act, but when the evidence threatens the core defense theory, it becomes an institutional lever. Once admitted, it cannot be unseen. It cannot be walked back. It redefines the terrain of the trial. And the defense reaction tells you exactly how seismic that shift was. They did not object and proceed. They did not request a sidebar. They attempted to leave the field entirely. Which brings us to the uncomfortable question the courtroom was forced to confront in real time. What happens when officers of the court decide the rules no longer apply to them? Judge Caldwell answered that question without hesitation. She did not debate motives. She did not entertain explanations. She asserted authority, activated enforcement, and drew a hard line. This is where the event stops being about Trump's lawyers and starts being about the system itself. Because once a court tolerates a walkout, it invites repetition. It teaches every future defendant that disruption is a viable tactic. That authority is optional. That trials are conditional. And the federal judiciary cannot survive that lesson. What froze that courtroom was not fear. It was recognition. Recognition by everyone present that they had crossed into territory with no precedent buffer left. And here's the part most people miss. The standoff did not end because the attorneys regained confidence. It ended because the system made clear it would escalate further. Arrest was no longer hypothetical. And just beneath that surface lies a deeper institutional fault line that had already been exposed before anyone stood up from that table. Because when 847 pages of evidence come in at once, and when that evidence directly contradicts sworn defense representations, the question stops being about admissibility. It becomes about what else the court already knows. The moment the defense stopped walking and turned back toward the table, the confrontation did not de-escalate. It deepened. Because now the attorneys had to explain themselves on the record. Robert Sterling stood first. His voice was controlled, but his words were incendiary. Your Honor, this court has abandoned all pretense of impartiality. We cannot and will not participate in what has become a predetermined show trial. That sentence matters more than it appears to. In federal court, accusing a judge of abandoning impartiality is not rhetoric. It is an allegation that strikes at the legitimacy of the proceeding itself. Sterling was not arguing evidence anymore. He was challenging the authority of the institution presiding over him. Jennifer Matthews followed immediately. This is prosecutorial misconduct at its worst, and we refuse to legitimize it with our presence. Refuse to legitimize. That phrase is not accidental. It is language imported from political protest, not legal advocacy. It signals that the defense no longer sees the courtroom as a neutral forum, but as a hostile structure. And then they moved again. Chairs scraped back. Papers gathered. Bodies angled toward the exits. This is where the system drew its line. Judge Caldwell did not allow debate. She did not allow momentum to build. She cut the action off with a warning that carried criminal consequences, and the attempt ended there. But the most consequential moment came next, when she explained why she had escalated so quickly. Here's where you need to understand the procedural earthquake beneath the surface. Judge Caldwell revealed that earlier that same morning, she had received a sealed ex parte submission from the Department of Justice. Ex parte means only one side sees the filing. The defense does not. The public does not. In federal criminal proceedings, this is almost never permitted. When it is permitted, it is for two reasons only: national security or witness protection. Let that sit for a moment. A judge does not disclose the existence of an ex parte submission unless she believes transparency is now necessary to preserve control. By saying this out loud, Caldwell was signaling that something bigger than evidentiary disputes was now in play. She stated on the record that based on the submission, she was considering enhanced security measures and potentially sequestering the jury. That sentence landed like a pressure drop in the room. Experienced defense attorneys know exactly what that combination means. It means the prosecution has a cooperating witness, it means the witness is vulnerable, and it means the testimony has the potential to destabilize the case. Former federal prosecutor Andrew McCarthy put it bluntly within hours. When defense attorneys hear about a sealed ex parte submission in a case of this magnitude, they know the walls are closing in. Someone on the inside has turned. This is the pivot point. Up to this moment, the defense had been fighting evidence. Now they were reacting to a person, someone with proximity, someone with access, someone whose testimony cannot be neutralized with procedural motions alone. That context reframes the attempted walkout entirely. Because when you cannot challenge the witness yet and you cannot see the submission, the only lever left is to destabilize the proceeding itself. And that is exactly what happened next. After the 7-minute standoff ended and the attorneys returned to their seats, Sterling's team immediately filed 2 emergency motions. First, a motion for a mistrial, arguing that the judge's conduct demonstrated bias and irreparably tainted the proceedings. Second, a motion demanding that Judge Caldwell recuse herself, citing her threat of arrest as evidence of personal animus toward the defense. This is where the tactic becomes visible. By provoking a confrontation, the defense created a record. By creating a record, they manufactured appellate hooks. Even if they lose on the merits later, they now have preserved claims of judicial misconduct. This is not accidental. It is structural. And the timing around it raises further questions. According to multiple reports, Fox News had camera crews positioned outside the courthouse approximately 45 minutes before the walkout attempt occurred. Several conservative commentators were already posting about judicial tyranny before the incident had been widely reported. That suggests anticipation, not reaction. If this holds, it points to coordination between legal maneuvering and media deployment, turning a courtroom conflict into a political message in real time. Which brings us to the figure now referred to only as Witness 14. The individual is mentioned in sealed filings. According to sources, this person has been in protective custody since October. That alone narrows the field dramatically. Protective custody of that duration is typically reserved for witnesses with direct knowledge of financial flows who face credible risk, not peripheral observers, not document custodians, someone central, someone with access to the money. Legal analysts have speculated that witness 14 could be a chief financial officer, a controller, or another senior financial insider with firsthand knowledge of the transactions at the heart of the government's case. If that testimony lands, as prosecutors expect, the defense's evidentiary position changes overnight, and Judge Caldwell's next move suggests she understands exactly how volatile this has become. She stated that given the attempted abandonment of the client mid-trial, she was considering appointing shadow counsel. Shadow counsel is not symbolic. It is a contingency mechanism. Court-appointed attorneys would sit at the defense table, fully briefed, ready to assume representation instantly if Sterling's team attempted to withdraw again. This is the judiciary protecting the Sixth Amendment, not for the lawyers, but from them. Because if defense counsel collapses under pressure, the court cannot allow the trial to implode with it. The consequences do not stop at doctrine. Financial pressure is already surfacing. Sterling's firm has billed more than $12 million in legal fees, according to filings. Following the walkout attempt, the firm entered emergency discussions with its professional liability insurer. Insurers do not call emergency meetings unless they see exposure. If the conduct leads to a mistrial, a successful appeal or disciplinary action coverage could be limited or withdrawn. That would place personal financial liability on senior partners. That possibility reframes the drama again, because now the defense is not only fighting the prosecution and the court, it is managing existential risk inside its own firm. This is where the power clash becomes multi-layered. Individual lawyers under pressure, a judge asserting control, a prosecution holding unseen leverage, media ecosystems amplifying conflict, financial systems tightening around the participants, and all of it orbiting a witness who has not yet taken the stand. Which raises the question the courtroom has not answered yet. Was the walkout an act of desperation or a calculated attempt to fracture the process before something irreversible enters the record? The political system reacted faster than the legal one. Within minutes of the standoff becoming public, Donald Trump posted on Truth Social, "My lawyers are fighters who will not stand for this rigged trial. Judge threatening arrest. Election interference." That post crossed 2.3 million views within the first hour. That number matters, because it confirms what many inside the courtroom already suspected: the confrontation was never confined to that room. It was instantly exported into the political bloodstream, framed not as a procedural breakdown, but as persecution. Here is where the institutional collision expands outward. Republican Senator Tom Cotton moved quickly. When judges threaten to arrest attorneys for defending their clients, we have entered Banana Republic territory. That framing is deliberate. It does not argue law. It delegitimizes authority itself. Democratic Senator Elizabeth Warren responded just as sharply from the opposite direction. No one is above the law, including lawyers who try to sabotage judicial proceedings. This is not partisan noise. It is an open split over who controls the courtroom when power is challenged. Public opinion followed with unusual clarity. A Reuters Ipsos flash poll conducted that evening found that 67% of Americans disapproved of the lawyer's walkout attempt. Nearly 48% of Republicans agreed. 72% said no one should be exempt from the law, including former presidents. That data point matters because it suggests something rare: the spectacle backfired with the broader public. Even the legal establishment began to recoil. Constitutional lawyer Alan Dershowitz, often sympathetic to aggressive defense strategies, stated publicly, walking out on a federal judge is simply indefensible. There are proper channels. This is not one of them. When figures known for stretching legal norms draw a line, it signals how far beyond convention this moment traveled. Then came a detail that deepened the concern. According to a defense paralegal speaking anonymously, Robert Sterling received a text message at 11:42, 5 minutes before the walkout attempt. 2 words only: abort mission. The source of the message, according to reports, was a senior Republican strategist advising on public relations. If that holds, the implications are severe. It suggests the courtroom disruption may not have been a spontaneous reaction to judicial overreach, but a coordinated maneuver designed to trigger media response and political alignment. Judge Patricia Caldwell appeared to reach a similar conclusion. In a written order issued later that evening, she included a striking passage. The court has reason to believe that certain theatrical elements of today's proceedings were coordinated with outside parties for purposes unrelated to the fair administration of justice. That sentence is not rhetoric. It is a judicial warning shot. She went further, outlining potential consequences, criminal contempt, financial sanctions, and referral to bar authorities. The system was now documenting intent. Security responded accordingly. United States Marshals elevated courthouse protection to the highest level. The FBI New York field office was placed on standby. The New York Police Department increased its perimeter presence. Additional metal detectors were installed. Sources also indicated that individuals linked to far-right militia groups were observed near the courthouse, though no specific threat was confirmed. This is not standard protocol for a white-collar trial. Inside the courtroom, the ripple effects reached the jury. Juror number 7, a retired teacher from Brooklyn, was observed shaking her head repeatedly during defense arguments. Juror number 3, a small business owner, took extensive notes whenever the judge addressed counsel. Jury consultant Dr. Patricia Williams later explained the psychology plainly. When jurors see this level of conflict between a judge and defense attorneys, they often interpret it as consciousness of guilt. Why else would lawyers risk their careers unless they believe the case is collapsing? History offers uncomfortable parallels. In 1978, mob lawyer Frank Regano attempted to abandon the Santo Trafficante trial. He faced disbarment threats. In 1992, during the BCCI banking scandal, attorneys attempted withdrawal and were forced to continue under threat of contempt. In 2009, Bernie Madoff's original legal team tried to quit days into testimony and was compelled to stay. In all 3 cases, the defendants were convicted. In all 3 cases, the attorneys suffered severe professional consequences. The pattern is not legal. It is institutional, which brings the system to its current inflection point. Judge Caldwell now faces decisions with no clean outcomes, whether to declare a mistrial, whether to recuse herself, whether to allow witness 14 to testify as scheduled. Each option carries risk. Delay invites manipulation, force invites appeal, disclosure invites escalation. And hovering over all of it is a larger question the courtroom can no longer avoid. If defense teams can transform trials into political theater, if authority must be enforced with armed marshals, if legitimacy is contested in real time across media platforms, then what happens next time? Not in this case, in the next one, with the next powerful defendant. If a federal courtroom can be pushed to the edge by spectacle and pressure, where exactly is the final boundary between the rule of law and raw power? Thank you for listening. Before you step away, share your perspective in the comments. If you found this breakdown valuable, hit like and subscribe, then turn on notifications so you don't miss the most critical political developments as they break day after day. See you next time.